All right. Good morning. So this live was scheduled for 11:30. It is 11:39. Why am I 9 minutes late? Because I literally thought I was live at 11:30 and I was recording myself live with the presentation and I actually wasn't live. So I was just talking to myself for the last 9 minutes. Apologies for the late start, but my name is Kristen Martinez. I am a Florida real estate attorney, and I created this channel to educate you, to educate Florida real estate agents, to educate home buyers and sellers, to educate real property investors. I file a lot of lawsuits, I defend a lot of lawsuits, and I don't want you to be a party in any of those lawsuits. That is the purpose of this channel. So let me know as we go through what questions you have in the comments. We are going to be taking a very deep dive this morning into seller's disclosure law here in Florida. We're going to look at the contract, we're going to look at common law, and we're going to review real court cases that went all the way up through the appellate level that will demonstrate some of the things I'm going to be teaching you this morning. So click that subscribe button. Let me know what comments you have or what questions you have in the chat. I'm doing this in the live format so that we can interact. I can answer your questions as you have them, and you can get as much value as possible from today's presentation. So, seller's disclosure law. We're going to start with where do we even get a seller's duty to disclose? And we get it from two places. The first place is the contract itself. And by that, I'm assuming that you are using one of the Florida Supreme Court standard approved contracts here in Florida. That's going to be your FAR standard version contract and your FAR as is version contract. Within the contract itself, the seller is making a very broad disclosure. We're going to review that. The second place that we get the legal requirement for disclosure of defects by a seller is in common law, and specifically from a case called Johnson versus Davis that was decided by the Florida Supreme Court in 1985. But let's start with the contract. So if you're using either version of the FAR contract, you will see the following language. I'm reading from the as-is version. It's paragraph 10J. I'm not sure if that's the paragraph it is in the standard version, but the language is identical. So the contract reads, seller knows of no facts materially affecting the value of the real property, which are not readily observable and which have not been disclosed to buyer. That is what I like to call kind of the catch-all seller's disclosure in the contract. If you are a Florida realtor, you probably know that there is a separate document called the seller's property disclosures. That document is not required to be filled out by the seller. It's not required to be a part of the contract to make it enforceable. However, in my legal opinion, I would recommend that a seller fill this document out every single time. And why do I say that? Most often, when a seller gets in trouble or gets sued for not disclosing a defect, it is not because the seller was, committing fraud or trying to trick the buyer into purchasing this property that has all sorts of issues. That certainly happens. But most often, it is the forgetful seller, the seller that repaired a leak in the roof 2 years ago and just forgot that that was something that they did and that they needed to disclose it. Or it's a seller that just honestly didn't know they were supposed to disclose that. Oftentimes, when we have issues that have been repaired, sellers think they don't have to disclose it. With water intrusion issues, it should still be disclosed because of the possibility of mold. A buyer who doesn't know about the water intrusion event, doesn't know to have it moisture tested or to have a mold test in that area. If it come to find out there was mold that buyer discovers after closing, seller could be sued and be held liable for that. So by using the seller's property disclosure document, what that does is that is a very detailed list of all of these different things dealing with the condition of the property that a seller should disclose. List of questions, seller's going to mark yes, no, or don't know. So what that does is that's going to help jog the seller's memory. That's going to walk them through a list of questions. One of those questions is literally, Has there been, prior or present leaks in the property? That's going to jog that seller's memory. Oh yeah, there was that leak that I repaired 2 years ago. Real estate agent, is that something that I need to mark down on this form? So it's going to help the seller disclose things that maybe they forgot about. It's also going to provide the seller with a list of items that they should be disclosing. Most sellers don't know what their legal disclosure duty is, and that document is going to walk them through what they should be disclosing. So my legal advice is that sellers should be using the seller's property disclosure document anytime they are selling a home here in the state of Florida. Yes, it protects the buyer. It also protects the seller for the reasons that I just stated. But even without that document, the seller is making in paragraph 10J that kind of catch-all disclosure. So let's take a look at the second place that we get the law regarding a seller's duty to disclose defects, and that is in the case of Johnson versus Davis. It was decided in 1985 by the Florida Supreme Court, and its holding is now the law here in Florida as it relates to sellers' disclosures. That court's holding is as follows: where the seller of a home knows of facts materially affecting the value of the property, which are not readily observable and are not known to the buyer, the seller is under a duty to disclose them to the buyer. This duty is equally applicable to all forms of real property, new and used. Keep in mind, this does not apply to commercial property. This is specific to residential property. The court was making a distinction there between new construction homes and pre-owned homes. The duty to disclose is the same. So from this holding in Johnson v. Davis, we get the 4 elements that must be present before a seller has to disclose anything here in the state of Florida. And those elements are as follows. Number 1, the seller has actual knowledge of the defect. This is one of the elements that is hardest to prove, because how do you prove what somebody knows or doesn't know? There are certainly ways. For example, the seller talked to their neighbors about it. All of the homes in a particular neighborhood flooded during a certain hurricane. The seller posted about it on social media. The seller contacted a contractor to come out and inspect things or give an estimate or do work to repair something. There are ways to prove that a seller has knowledge, but the element here is that the seller has actual knowledge of the defect, and that is not constructive knowledge. Constructive knowledge means the seller's agent has knowledge. So maybe the seller hired a contractor, the contractor did work. While doing work on the property, the contractor discovered water damage, for example, but never told the seller about it. They just went above and beyond and went ahead and fixed it and didn't charge the seller for it. In that case, the seller's agent, the person working on behalf of them, this general contractor, has knowledge, but they never disclose that knowledge to the seller. So the seller doesn't have actual knowledge of the defect. Actual knowledge is the standard here. So element number 1 is the seller has actual knowledge of the defect. Element number 2 is that the buyer has no knowledge of the defect prior to closing. So even if at the time the contract is executed, there was something the seller should have disclosed and they didn't, if the buyer finds out about that issue at some point prior to closing, the buyer's remedy is to terminate the contract and not close. If the buyer moves forward with closing and they have knowledge of that defect at that point, they cannot come after the seller after closing for their damages. They have waived their right to do that. So element number 2 is the buyer has no knowledge of the defect prior to closing. I see we have some new people join. So again, leave me your questions in the chat. This is a live format so that we can interact together. I can answer your questions. So let me know what questions you have. All right. So element number 1, the seller has actual knowledge of the defect. Element number 2, the buyer has no knowledge of the defect prior to closing. Element number 3, and this is the one that trips up most buyers, is the defect cannot be readily observable. It cannot be open and obvious. In other words, it is a hidden defect. What do I mean by that? A defect is open and obvious if When you're walking through the property, it's visible to the naked eye. So we're in Florida. I like to use water intrusion as my example. But if you're walking through the property and you see a water stain on the ceiling, that water leak, the seller does not have to disclose because evidence of the defect is open and obvious. It can be seen by visual inspection of the property. Now, if the seller has painted over that water stain so it's no longer visible, that's a different story. Another item that most buyers don't recognize is if a defect can be discovered by the review of public record, it is open and obvious. It is not a hidden defect. This is a burden on the buyer that I personally believe is unfair. Most buyers are not going to know that they have to scour the public record for evidence of any defect on the property prior to closing. That they don't realize that's part of the extent of the due diligence they're required to do. But that's the law, and if it's part of the public record, it's open and obvious. So if there was a previous sinkhole that was remediated and there was a permit pulled for that work, that permit is public record. Let's say owner number 1 has that sinkhole repaired. It's public record. There was a permit pulled and closed out. They do not disclose it when they sell the property to owner number 2. Owner number 2 is deemed with having that knowledge because that permit is part of the public record. So that is not something that a seller is legally required to disclose. If there's been a lawsuit filed about a certain defect in the property, lawsuits are public record. You don't have to disclose them. HOA documents, those are public record. So if there's rental restrictions or something in the HOA documents that the buyer doesn't like, they need to pull those and review them because a seller does not have to disclose what is in the public record. So that's element number 3, that the defect must be a hidden defect. And element number 4 is that the defect has a material effect on the value of the property. Now, what does that mean? It depends. That is going to differ based on what the value of the property is. $1,000 repair item might have a material effect on the value of the property. If we're talking about a $75,000 property, I don't know if that exists anymore, but it certainly doesn't have a material effect on the value of the property if we're talking about $1 million property. So generally the takeaway here is we're not talking about cosmetic issues or repairs and things like that. The cost to repair the defect has to have a material effect on the value of the property, or it has to affect the value of the property going forward, meaning the buyer, after they close, they find out about this defect that was never disclosed. When they go to sell the property, they now have to disclose it, and now they're going to be able to sell the property for a lot less. That's an example of having a material effect on the value of the property. So, in review, all 4 elements must be present before a seller has a duty to disclose any defect to a buyer. Those elements are that the seller has actual knowledge of the defect, buyer has no knowledge of the defect prior to closing. The defect is a hidden defect. It is not open and obvious. And number 4, the defect has a material effect on the value of the property. So let's say all of those elements are present and the seller still fails to disclose a particular defect. What is the buyer's remedies? So the buyer moves forward with closing. They move into their home. The first time it rains, there's flooding all in the home. Water comes in, through the garage, through the front door, wherever. And come to find out, the seller knew about this because the seller dealt with the same flooding issue every time there was a heavy downpour here in Florida and didn't disclose that to the buyer. What claims would the buyer have against the seller? There are 3 claims, which when we file lawsuits, we file all claims that apply. So we typically file all of these. Number 1 is going to be breach of contract. As we reviewed in paragraph 10J of the contract, the seller's making that catch-all disclosure, and they violated that paragraph of the contract by not disclosing this issue. So number 1 is a breach of contract. Number 2, the second claim a buyer would have is for fraud in the inducement. What does that mean? Fraud in the inducement means that the buyer, had they known of this defect before signing that contract, either they never would have signed the contract or they wouldn't have signed the contract at that same purchase price. They would have paid less for the property. So that's fraud in the inducement. That is the seller either making a misrepresentation to the buyer, saying there's never been a leak. I don't know anything about water intrusion when it rains. That's never happened. That's a lie. That's a direct misrepresentation, or a material omission. So the seller doesn't have to come out and flat out lie about it, but they can know that this happens every single time it rains and just conveniently fail to disclose that to the buyer. That is a classic case of fraud in the inducement. The third one is fraudulent misrepresentation, very similar to fraud in the inducement, but that can happen even after the contract is signed, whereas fraud in the inducement occurs prior to and leading up to the signing. They were fraudulently induced to sign the contract. So those are the three claims a buyer would have available to them. They would also have a couple of different remedies. The first one is money damages. So this defect wasn't disclosed. I had a contractor come out here. It's going to cost me X amount of dollars to repair this defect, or to put in drainage so water doesn't intrude every time it rains. And also, if I don't have it fixed, I'm going to not be able to sell the property for what I bought it for, accounting for market fluctuations. It's automatically worth less than what I bought it for because of this defect. Those are monetary damages. And that is one option the buyer has. The second option that the buyer has is for rescission of the contract. So that remedy entails basically undoing the contract, unraveling the transaction, and putting the buyer in the exact same position they would have been had they never signed the contract. So they deed the property back to the seller returns the money back to the buyer, and the contract is unwound and it is undone. The buyer has to choose one of those remedies. They can't get both. The third thing that the buyer is going to seek, again, if you're using one of the standard FAR/BAR contracts, whether that be the standard or the as-is version, is recovery of their attorney's fees and court costs. That is a third item of damage they would be entitled to. So now we've gone through when a seller has a duty to disclose and where that duty comes from. We've gone through if the seller violates that duty, what the buyer's claims are, and what the buyer's remedies are. Now we're going to take a look at two different court cases that I think will do a good job of demonstrating some of these items that we've gone through this morning, and we'll kind of put into perspective how this kind of plays out in real life, or when there's an actual dispute and lawsuit filed. So this is a 2005 case titled Jensen versus Bailey. This is out of the Second District Court of Appeal, which governs the area that I'm in, which is the Tampa Bay area. I'm going to give you the facts of the case. We're going to talk through it. I'm going to ask you to throw in the chat what you think the judge's decision was at the end of it. If you do participate, or if you don't participate, I'm going to tell you the answer, and then we'll take a look at another appellate court case as well. So in this case, the Jensens entered into a contract with the Baileys for the sale and purchase of their residence. So the Jensens are the sellers. The Baileys are the buyers, and this was a home in St. Petersburg, Florida. Before the parties signed the contract, the Jensens filled out a seller's disclosure statement for the Baileys or the buyer's review. One of the questions on the disclosure statement was whether the sellers were aware of any improvements or additions to the property, whether by you or by others, that have been constructed in violation of building codes or without necessary permits. In response, the Jensens checked no. So the official disclosure here from the sellers was that we're not aware of any improvements or additions that violate building codes, or that were done without pulling and closing out necessary permits. After closing, the Baileys made some discoveries. The buyers made some discoveries. There were 3 unpermitted changes to the home that were not in conformity with the building code and would require complete reconstruction. So prior to them selling the home, the Jensens had substantial remodeling work done in the kitchen, the master bathroom, and the master bedroom. All of these projects required permits. Neither the Jensens themselves nor the contractor they hired obtained any permits. And then the evidence at the trial in this case also showed that these renovations were not done to code. There was no evidence presented at trial that the Jensens, the sellers, actually knew about the unpermitted or the inadequate work. But there was evidence that the general contractor they hired did have knowledge of these issues. What do you think the court did? Are the sellers liable for not only failing to disclose this issue, but misrepresenting to the buyers on that disclosure statement that there was no work done that was not properly permitted or that violated building codes? Come to find out, there were 3 items done to the property that none of them had the proper permits. None of the 3 were up to code. Throw in the chat here what you think the court did. I'd be interested to see. All right, seller had to know about the defect. Actual knowledge, court rules for seller. Thank you for that. All right, any other guesses here? All right, so the court in this case held that the sellers were not liable. And it all comes down to the knowledge element. Tampa agent says seller was not aware. So specifically, the court held that the knowledge requirement in Johnson v. Davis, that's the Florida Supreme Court case that controls all of this, requires actual knowledge and not constructive knowledge. So this is an example of constructive knowledge. The seller hired the general contractor. They said, we want to remodel all this stuff, and here's what we want it to look like. You're the expert. You're the professional. You go do it. Contractor went and did it. The contractor knew they needed permits. They're an expert. The contractor knew the building codes. That's their job to know those things. The seller's a lay person. They didn't know what needs permits, what doesn't, what the codes say, whether this particular work was up to code. And so while this seems to be a very unfair result for the buyers, sellers aren't liable here. That knowledge requirement is very specific. Actual knowledge is required, and the buyers were not able to present any evidence at court, at trial, of actual knowledge. The sellers weren't, talking to their neighbors about, yeah, I hired this contractor and I got a discount because he's not going to do permits. There was no evidence that the sellers knew. So thanks for your participation. I do see a question here that I missed. Do prior news and weather reports count as public record, using flooding as an example? Very interesting question. So I have used successfully at trial the fact that a particular neighborhood is known for flooding every time it rains. They make the news when there's a hurricane or a tropical storm because everyone's flooded out. It's disastrous. It's catastrophic. I have used that as to demonstrate that a defect is open and obvious. A quick Google search would have shown you. And really, it applied, at least in my case, to the agents. So the agent representing the buyers, in my case, sold and helped people purchase homes in that particular area all the time. Very experienced agent, very knowledgeable about that particular area, and knew that particular neighborhood had issues with flooding. And remember, a buyer is represented by their agent. And so any knowledge that the agent has is imputed to the buyer. So if an agent has knowledge and they don't tell the buyer, it doesn't matter. The buyer is deemed to have that knowledge by law, fair or not. That's what the law is. So very interesting question. I think it works sometimes, other times I don't think it does. So if the only piece of evidence was one news article from 10 years ago that there was flooding, there's nothing else in the public record, there's no evidence in the actual property itself of any sort of water damage, I think that would be a tough argument. I would use it all day long if I were representing a seller, but so I think sometimes it works, sometimes it doesn't. So agreed, seller didn't know, seller likely knew but denied it for liability issues. So that's also the thing with seller knowledge. How do you prove what somebody knew? If they knew but they were smart and they never told anyone that they knew. They never talked about it. They didn't post about it on Facebook. They didn't email or text anyone about it. They don't have in their Google search history, how many times has this house flooded in the past, or when are permits required when you're remodeling your bathroom. If there's no traceable evidence like that, seller may have known. We'll probably never know the truth on that, whether they knew or didn't know. All right. The second case we're going to take a look at is Eyman versus Sullivan. This is a 2006 case. I know these are old cases, but they take a long time to go through the court system. And once they're appealed, the appellate court kicks it back to the trial court for a new trial, and it has to go through that whole system again. So things in the legal world move very, 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 very slowly. But I also try to pick the best ones with facts that I think are relevant to what we're talking about. So in this case, the Sullivans, who are the buyers, they purchased a plot of vacant land from the Eymans for the express purpose of constructing their future dream home. Although the buyers visited the property multiple times before signing the contract and after contract, but before closing, the buyers never performed any sort of testing or assessments on the property to determine whether it was suitable to build the home that they wanted to build on it. After closing, the Sullivans, the buyers, they hired a builder. The builder began the process of submitting plans to the county so that they could obtain a building permit. The permitting process included performing a subsurface investigation of the building site, which had not been previously done. The investigation revealed subsurface conditions consisting of fine sand with organic silt, parentheses, muck. That is a quote from the case itself. At various depths within the proposed building site, which would require deep foundations and large timber piles to support the construction of the house. So based on this study, the builders told the Sullivans that their initial estimate would increase by $65,000 because now they're going to have to install these pilings and things to strengthen the foundation and support the weight of a home on the property. So an additional $65,000 would satisfy that requirement of having a material effect on the value of the property. The Sullivans, who are the buyers, filed a complaint against the sellers and the seller's broker, alleging, among other things, that they breached their duty under Johnson versus Davis by failing to disclose to the Sullivans a fact known by the sellers, which was not readily observable and that materially affected the value of the property. So the buyer sued the seller saying, you knew that this vacant land was not suitable for building a home. You also knew that that's the only reason why I was buying this land. I told you that because I wanted to build a home on this property after closing. You knew that. I didn't know that. It was not readily observable. I don't know by walking onto this vacant plot of land and looking at it that the soil and the subsurface conditions are not adequate for building a home, and it has a material effect on the value of the property. The sellers, on the other hand, argued that their duty to disclose under Johnson v. Davis does not apply to vacant land to be used for residential purpose. That was their argument number one. Argument number two is that even if that disclosure requirement in Johnson v. Davis did apply, the buyers failed to prove the elements of the claim. The buyers argue that Johnson does not apply the sellers argue that Johnson does not apply and that they presented competent, substantial evidence to support the final judgment in their favor. So the issues here are, do we have the four Johnson v. Davis elements in this case? Number one is that the seller had knowledge. Did the sellers know that the subsurface conditions of this vacant land was not adequate, or at least without some sort of piling or additional foundational work adequate to build a home? Did the buyers lack knowledge of that? Was it a hidden defect, and does it have a material effect on the value of the property? Let me know in the chat what you think, and then I will disclose the court's holding to you on this one. All right, I'll give a couple more seconds here to see if we have any guesses on whether the seller is liable for not disclosing this issue to the buyers prior to closing. This one must be a little bit more difficult because I see nobody brave enough to enter their guess in the chat. That's okay. So let's go through the court's holding. We have one here. They did not know, only that there was muck involved. So I assume you're saying here no liability on the part of the seller. So this is the court's holding. We conclude that even assuming the application of Johnson v. Davis to the facts of this case, the Sullivans, who are the buyers, failed to present competent substantial evidence of the existence of a fact that materially affected the value of the property in question, and that the sellers had actual knowledge of that fact. The buyers failed to prove the allegation in their complaint with the respect to material fact element of their Johnson claim. The evidence presented showed that the property as a whole, and this is the court's language here I'm reading from, the evidence showed that the property was buildable in the sense that the house that the buyers wanted to build, as well as any other structure, could have been built, just with some modifications to the foundation. But that proving that a layer of muck exists below an area of land filled in by the sellers does not constitute competent substantial evidence of a fact materially increasing the cost of the Sullivans' future home. So the court here relied on that last element, really on two elements. Number one, seller knowledge, and number two, material effect on the value of the home. Buyers, you purchase this property to build a home on it. You can, in fact, build the home that you wanted to build on this property. You're just going to have to do some additional work prior to that to the tune of $65,000. The court didn't discuss it specifically, but something else I would imagine went into the court's decision is the buyers signed this contract and proceeded with closing without ever having a professional come out there and do any sort of soil testing or subsurface testing to see if what they wanted to build was actually feasible. That was up to the buyer to do. It's not the seller's job to make sure that this property, this land, is perfectly suited to what the buyer's intended use is after closing. Did the court weigh the fact that the buyers never tested it? Exactly. So we're on the same page here. So I think that goes into it. Again, here in Florida, it's very much buyer beware. Buyers have a huge burden to do research and due diligence to make sure that a property is suitable for their needs, that the price that they're paying for the property is worth what the property is in its current condition, all of those things. And so, in my opinion, it was up to the buyers if they wanted to ensure that they could build this particular house on this particular property. They needed to have the right professionals come out there and confirm that for them. That way they have full knowledge going in, whether they can do what they want to do and how much it's going to cost. All right, so that concludes our discussion today of sellers' duty to disclose here in Florida. Thank you for your participation. Thanks for the questions. Again, make sure to subscribe to my channel. It's a new channel. I would appreciate it very, very, very much. Again, my goal is to educate you guys. So let me know what topics you want to hear about, what questions you have. I will address them. I will do videos on them. And I'm going to be scheduling some more lives so that we can have this discussion and interaction. We're going to go through more real estate law in Florida with real case studies to kind of practically show how these all play out. But thank you again. Have a great Friday. Have a great weekend. I will see you soon.